Welcome. Thank you for taking the time to listen to this explainer on the proposed enterprise agreement that was circulated on 8th of December. My name is Joo Cheong Tham. I'm the NTEU Victorian Assistant Secretary for Academic Staff and also a professor at the Melbourne Law School. And I'm joined here by Jacob Debets, the NTEU Industrial Officer. And what we aim to do in this presentation is provide an explainer in terms of this enterprise agreement. But let me begin first by acknowledging the traditional owners of the various lands upon which we meet, and to emphasize that sovereignty was never ceded. Now, as I mentioned, the purpose of this presentation is as an explainer, and what we aim to do here, and I'll set up the structure in the next slide, is really draw up the salient points to give members a sound understanding in terms of what is being proposed, details of which are contained in two documents that provide more fulsome detail. There's, of course, the proposed enterprise agreement itself, which has the actual clauses, and there's a summary of the proposal that accompanies that proposed enterprise agreement. And this explainer, together with the documents, is part of a more general effort, of course, to ensure that members are properly informed as to what's being proposed, and there are 3 members' forums of which details will be provided in email sent to members. In terms of the structure of the presentation, it falls into 2 parts. The first is an overview, and secondly, there's a more sort of a in detail focus on the priority claims made by the union. I will be taking the first part in terms of the overview, and Jacob will take the second part in terms of the priority claims. In terms of the structure of the overview, what I propose to do is really look at the enterprise agreement from different vantage points. Importantly, the proposed enterprise agreement needs to be judged against the existing enterprise agreement. So what we'll have in terms of the first part of this overview is identifying the new entitlements and protections under the proposed enterprise agreement, as well as the improved entitlements and protections. We'll then move on to certain provisions that are proposed in the enterprise agreement that were initiated by the management of the university and give you a sense of the likely impact on protections. And then at the end of the interview is really assessing the proposed enterprise agreements against the claims made by the NTEU proposal. And of course, and I've said this before at earlier members meeting, claims are not outcomes. And the claims do set our agenda in terms of what the union is seeking to bargain for. At the same time, it's only when provisions make their way into an enterprise agreement that claims become outcomes. In terms of priority claims, I won't go into much detail here. You can see in the right-hand column that we had 7 priority claims, and Jacob will take you through the detail in terms of those priority claims. New entitlements protections. And what you see in this slide and the slide to come is that the proposed enterprise agreement achieves a whole range of new entitlements and protections. On the first dot point on the left-hand side, and it's of crucial importance in terms of professional staff, is that professional staff now has improved access to working from home in the sense that management is obliged not to unreasonably withhold agreement to request to work from home. There's a right to disconnect. Importantly, in terms of workers' voice, there's now a joint consultative committee comprising of management as well as union representatives. We have a series of gender equity measures that have been achieved in this proposed enterprise agreement. Gender affirmation leave of 30 days per annum, special leave, including for chronic health conditions and menopausal conditions, 10 days per annum, paid lactation breaks and facilities. We also have in the proposed enterprise agreement, in terms of new entitlements protections, preferential arrangements in respect of ongoing jobs for existing insecurely employed employees. And let me stress here, in terms of insecurely employed employees, they're both casual and fixed term. In terms of dealing with workload, there are new protections in terms of an obligation on university to recruit for vacancies in a timely fashion, as well as to backfill and reorganize work when there are planned absences of 4 weeks or more. And again, in terms of new entitlements, What we see in terms of the existing enterprise agreement, and Jacob will go into the detail of this, is that there are basically no entitlement to minimum resource allocation presently, but that's been achieved in terms of this proposed enterprise agreement. And lastly, in terms of this slide, what we have in terms of a new provision is that Labor Day and Melbourne Cup holidays will now be public holidays under the enterprise agreement and no longer be substituted for additional days over the annual shutdown. Very crucially, and this has been crucial in terms of the NTEU bargaining agenda nationally, as well as this branch, are the First Nations claims. And under this particular heading, the proposed enterprise agreement has achieved a number of improved entitlements and protections. The university will be under an obligation to develop an anti-racism and cultural education program during the life of the enterprise agreement. There's now recognition of cultural load in the workload allocation of our Indigenous colleagues. Indigenous colleagues too will have 10 days cultural leave, as well as 3 days bereavement leave. And 26th of January will now now be a facility for all employees to substitute 26th of January for another day of work. And still with improved entitlements protections, and you see this fair bit of detail on these slides, and this slide pack will be provided to you separately. So please feel free to go back to the detail if you want to. Salary increases, Jacob will go into the detail of that shortly. We have one sector leading parental leave, effectively 38 weeks upon commencement employment. Gender equity measures in terms of domestic and family violence leave, exclusion of parental and carers leave in terms of academic confirmation. Now, as you know, too, one of the key bargaining agenda items for this branch has been job security. And the thrust of those claims has been to really invert the insecure workforce model of the university and to base it on continuing employment being the main mode of employment. And what is in this proposed enterprise agreement, and this dot point number 5 on the left column, is essentially that principle being enshrined in the proposed enterprise agreement, where the continuing employment is set, in its words, as the preferred option for engagement. Now, the details that Jacob will go into, and I'll run through this reasonably quickly, but in terms of a high-level summary, alongside that workforce planning clause and what it says in terms of targets for increasing continuing employment and reducing insecure forms of employment, such as casual employment, there's stricter limitations on the use of fixed-term employment, conversion provisions after 2 years of fixed-term employment, and as well as a facility for casual conversion after 3 years. Now, alongside job security were the critical claims in terms of workload. And the aim of those workload claims, and Jacob again will go into the detail of this, is essentially to ensure that employees at this university work their legally stipulated hours. So that's 36.25 hours per week for full-time employees and prorated for part-time employees. And what has been achieved in this proposed enterprise agreement are a series of mechanisms aimed towards that goal. There will now be under what's proposed under this enterprise agreement is a university-wide review of workload allocation practices that is evidence-based. And that evidence-based review will also require the public transparency in terms of publication of workload allocation policies. There will also be specific review of workload after organizational change. And this was an important concern for all staff, particularly professional staff. Individual workload allocation under this proposed enterprise agreement is required to be evidence-based. And alongside these improved entitlements in terms of salary, gender equity, job security, and workload, we have to improve entitlements in terms of union rights, specifically in terms of time release and trade union training leave, improve protection of academic freedom, and also, and this is critical in terms of our casual academic colleagues, a clear statement that there'll be a rate of pay that's higher for those who possess a doctorate qualification. What's critical is what's in and it's also what's out. The whole series of management claims that are not in this proposed enterprise agreement, which the bargaining team has succeeded in fending off. And let me run through that. There was a proposal to require academics to have prior approval to work from home. That's not in the proposed enterprise agreement. There was quite a wide-ranging proposal in terms of misconduct, both in terms of diluting the review process, standard of review to review a process, not to the merits, and carving out from review and dispute resolution, dispute and grievance procedures, a whole range of serious misconduct, including bullying, assault, discrimination, and vilification. There was also a proposal to allow the contracting out from the enterprise agreement standard of 3 months of notice for termination of academic staff. With casual employees, the earlier iterations of the university's proposals in terms of the payment schedules, essentially base payment on scheduled hours, without, as we'll see shortly, a requirement for them to actually ensure those hours required are sufficient and reasonable. There was also a proposal to basically aggregate hours across the entire day with no recognition of whether how far the break might be between different occasions of engagement. And then lastly, on this slide, what's not in the proposed enterprise agreement is the university's superannuation offset proposal, which essentially allowed the cashing out of superannuation payments above the statutory minimum. There are provisions here in the proposed enterprise agreement that are management initiated. And what this slide seeks to do is give a sense of what the likely impact is on protections. So the wide-ranging proposals in terms of misconduct have been narrowed down extremely considerably, and they now only apply to serious misconduct from sexual misconduct and breaches of the child safety policy, and they only occur when the university has made clear findings of fact. There are also changes in terms of medical retirement that, in my view, have a negative impact, but a very limited impact. So what we have now in terms of medical retirement is going to be based on independent medical examination, and let me stress independent, but there's a removal of the review in terms of by a medical panel. In terms of other management initiative proposed provisions, 2 of them are, in our view, have a positive impact. There's a facility to fund continuing research contingent employment in the sort of break period between different grants. There's an introduction of graduate research associate roles, which in our view basically firm up to some extent the sort of career pathways in terms of academics. Others have a neutral impact, supplementary work, and what this means is really work that's done in addition to work in the main role, and high duties. And what we have on this slide is management initiative proposed provisions dealing with casual employment. So the first 2 have a positive impact. Penalty rates are in what's going to be the new proposed to be the new Division 4 for weekend and public holiday work, and that will be provide for increased pay when they come into effect. And what the proposed enterprise agreement stipulates is that they come into effect after the various scheduling processes of university have been put in place. Now, in terms of the second line on this particular slide, and I alluded to this earlier on, so what is in the proposed enterprise agreement is a change in terms of the payment entitlement to required hours. Now, the initial proposal of management was essentially required hours was what hours were scheduled by the university or by the managers under university. What's important in terms of the proposed enterprise agreement, and for the first time, yeah, and this is that's why it's a new entitlement, is that the university is obliged in the quantum of the required hours to ensure that it provides sufficient and reasonable time for the casual employees. And what we have in the proposed enterprise agreement are a series of procedural safeguards to ensure that sufficient and reasonable time obligation is complied with. In our view, that will be positive, with the big caveat that there be compliance with that sufficient and reasonable time requirement. There are two other changes that have a negative impact, but perhaps limited in depth. The minimum engagement obligations have been reduced in relation to remote work. Yeah, so this is really in recognition of the fact that remote work doesn't require the commuting time to the campus and so on and so forth, and that it was not unreasonable that you reduce minimum engagement given that particular circumstance. The aggregation provision that was proposed by management has been considerably scaled down in a sense that hours can only be aggregated when the break between engagement is less than 2 hours. Now, this is another vantage point to sort of think about what's in the proposed enterprise agreement. And these, of course, are the claims that the union have made. And bearing in mind, of course, claims are not outcomes. Claims essentially demarcate the agenda that the union is pursuing. And what you see, and Jacob will go into this in much more detail. So I'm just going to scan, this particular slide. We had priority claims on salary, job security, organizational change or restructuring, the way we put it, working hours and workload, working from home for professional staff, minimum research allocation for academic staff, and parental leave. Now you see, of course, there are yellows in terms of the right-hand column, in terms of when partial wins in terms of salary, the target of 70% continuing employment, working hours and workload, working from home for professional staff, and minimum research allocation. And those yellows also sit alongside clear greens, yeah? Greens in terms of key job security measures, greens in terms of organizational change and restructuring, and a very bright green in terms of the parental leave claim. And alongside the priority claims, a whole series of claims, and you can read the detail in the slide pack that we provided. But you see, of course, in that right-hand column, yeah, a whole series of important areas where basically there are greens, where they're close to full wins or full wins. What is a red in the first column was a claim for paid sick leave for casual employees. And the university has been adamant in saying no to this particular claim. Now, this is the point where I will hand over to Jacob to go more into the detail in terms of these priority claims, and really, again, in a way, following the two vantage points, that I adopted in the earlier part in terms of matching up what's in the proposed enterprise agreement with the claims we made, but importantly, okay, where we're at right now in terms of our existing enterprise agreement. On to you, Jacob.
Thanks, Joo Cheong. So as I've done, and as Joo Cheong and I have done at the members' meetings throughout this bargaining process, which has been going formally for 16 months, but informally for closer to 2 years, I'm just going to step through the priority claims, the biggest priorities that were most widely and deeply felt by members and which featured prominently in our industrial action. So number one is, of course, salary. The university's initial proposal, which was first tabled after the first one-week strike in August, was 4% in 2024 and 4% in 2025. The university said right throughout the intensive negotiations that it was their first, final and best offer, and there was nothing that would move them to increase it. That was obviously not correct. They have increased it. They've proposed in this agreement a additional 0.5% in 2025. It does fall short of our claim for a 2% back pay effective in 2022, but it is nevertheless more money in our members' pockets. In respect of job security, we were ultimately able to, as part of this proposal, there is a workforce planning clause that critically embeds in the enterprise agreement a requirement to maintain a more secure workforce profile. So a core workforce consisting of 75% full-time equivalent core workforce of continuing positions and 18 months fixed-term positions. But within that framework, there's a requirement, there's basically ladders, so requirements to grow continuing jobs, increase the proportion of continuing employment relative to fixed-term employment within the core workforce, which means to meet that target, and there are a few hundred jobs off, they need to make more ongoing positions than they do fixed-term positions. There's also requirements to basically build on the decasualisation efforts that have been underway over the past several years as a result of our wage theft campaigns, including in respect of reporting obligations to staff and to the unions. To look at what's in the agreement versus our claim, we obviously had sought for the workforce planning job security target to consist entirely of ongoing jobs, and that is not embedded in it. It does include some fixed term, but we were able to basically build in that decasualisation and ensure reporting obligations in respect of the Joint Consultative Committee. We were also able critically to embed preferential hiring arrangements for staff who are currently employed at the university on a casual or fixed term basis. Within the workforce planning clause, there is a right of first apply, which basically gives insecurely employed staff the first right to apply for jobs through an internal recruitment process. So ongoing vacancies and new secure jobs that are created as a result of the target. There's also a positive obligation on the university to exhaust reasonable endeavours to transfer existing employees into those new ongoing jobs, which applies in relation to internal candidates who've been employed by the university over 2 or more semesters in the previous 2 years and who are on a 0.5 or above fraction. Quite significantly, there are also much greater restrictions on the use of fixed-term contracts. There is now basically only 3 categories of accepted fixed-term contracts in the agreement, down from 5, which is a really significant restriction and complements the work that the university is doing currently to apply or interpret and apply the new fixed-term provisions of the Fair Work Act. In addition to restricting the circumstances under which fixed-term employees can be engaged, there are also pathways to convert existing fixed-term employees. So staff who've been employed on successive contracts at the university for more than 2 years are entitled to be offered ongoing work where the university identifies that as an ongoing role, and where at the point of commencement in their position, they were appointed through a competitive process subject to satisfactory performance. So all of these claims in job security intersect in ways to make the university a much more, well, it needs to prioritise ongoing employment, and our prediction is that there will be many hundreds of jobs, ongoing jobs created as a result of how these positions interact and apply over the next 2 years, in addition to the work that the university has been doing to move towards more secure employment as a result of the amazing wage theft campaigns and the structural change that has brought on in the university. I'll speak now briefly about workload. So we weren't able to get the university to agree to embedding a positive duty in the enterprise agreement to ensure reasonable work hours, but we were critically able to win almost all of our other claims. So an evidence-based review of workload practices over the life of the agreement and a report by the end of the agreement, so in 2 years from the commencement, if it's accepted, with an opportunity for staff to participate in that review and provide provide submissions and be consulted on the terms of that review. The publication of current workload allocation policies, which is currently something that's quite spotty across different faculties and work areas. A requirement, critically, that workload be established in a manner that, in respect of academics, is derived from from applicable evidence-based workload allocation, and then for professional staff, derived from a reasonable assessment of the time taken. So in circumstances where the university is not currently applying workload in a reasonable way, or in respect of academics, not applying it from an evidence basis, there will be an avenue to change that. There are also requirements that the university will need to comply with to ensure that workload issues that are created by vacancies or temporary absence of staff, those circumstances will be more limited. So there's a requirement to recruit vacant positions in a timely fashion, and also a requirement to backfill staff or reorganise work in respect of planned absences of 4 weeks or more. So those are the circumstances where staff are forced to absorb workload of other staff when there's not those positive obligations in place to reorganise that work. So again, all of these claims intersect and holistically they ensure the university is proactively getting across the workload problem, which for a long time it's denied, transparency in relation to how workload is allocated through policies, ensuring evidence-based time estimations for workload allocation, and ensuring review of workloads after organisational change, which I'll talk about in a second. In respect of minimum research allocation, critically, at the moment, the university does not have any obligation under the enterprise agreement to provide any minimum research or any sort of minimum allocations in academic workload across teaching, research and service. And we do know that during COVID, there were some staff whose research allocations were unilaterally reduced. So what we were able to achieve at the bargaining table, which was pretty close to what our claim was a minimum research and or professional practice allocation for continuing academics of 20%, where they're 0.8 fraction or above, and a 10% minimum research or professional practice allocation for staff who are on less than 0.8. Now, critically, that minimum allocation can be used exclusively for research in respect of the 0.8 fraction. And there are also provisions which prevent the university from unilaterally reducing workload unless it can be shown not to be detrimental to an academic's career, promotional prospects, and or discipline currency. And our view of how that provision would operate is there would be almost no circumstances where that could happen. So that critical grandfathering of existing research staff is a really big achievement. In respect of working from home, again, another issue that the university initially said that they would not put in the agreement under any circumstances. There is now a requirement that the university cannot amend its working from home policy other than to enhance protections of staff. There's a requirement that employee requests to work remotely will not be unreasonably withheld, subject to the policy and lawful and reasonable directions to be on campus. There's explicit provision which ensures that academic staff do not need permission to work from home in respect of self-directed academic work. That's always been the practice at the university, but now it is embedded in the enterprise agreement and provides that critical protection. We did not get the full unqualified right, and we did not get the requirement to facilitate remote working where practicable. But in the large part, that working from home claim has been largely satisfied. In respect of organisational change, there are enhanced protections for staff against excessive redeployment or redundancy processes. And there's also a requirement that the university conduct a workload review for staff whose role has been affected by organisational change. So at the moment, staff are required to basically lodge a workload grievance, which we know very few people do for a number of reasons. Now that university has a positive obligation to conduct that workload review and inform itself of any work intensification, inform itself and remediate any work intensification that has happened as a result of restructures and change plans. Parental leave entitlement, one of the early wins in the campaign. At the moment, staff have an effective entitlement to 24 weeks of leave after a year, or 36 weeks leave after 5 continuous years. Under the proposed enterprise agreement, fixed term and ongoing staff now have an effective entitlement to 38 weeks parental leave from the day their employment commences, which is a sector leading, and in a lot of cases, a labour market leading entitlement, which will really massively change people's lives if this agreement goes through. That's it from us. We will have more information and an opportunity for members to ask questions and be fulsomely consulted on the full agreement. The dates and times of those are being firmed up, but they will take place in the week of the 11th. Yeah, please refer to the branch email or website for more information about those things. Thank you so much for joining me and Joo Cheong. I'm sure we'll see many of you at the forums next week.